Society. I am, in essence, a private adjudicator and a regulatory lawyer.
Yes. Do you still appear in court or not anymore?
Well, in essence, I've spent most of my time hearing cases. I don't know whether you've had a detailed look at my CV, but perhaps I can just quickly run through.
No. You can just mention a few things that you believe,
Yes.
stand out and are supportive of your candidacy.
Yes, indeed. Thank you, Chief Justice. Well, I want to start off by saying that I've spent a lifetime working in the trenches of independent tribunals, which have been established to give meaning and content to Section 34 in the Bill of Rights of the Constitution. You're aware that that provides access to the right of access to courts and to independent tribunals. I've sat in a special electoral court in 1994. I've been involved in the Landlord-Tenant Board, Consumer Affairs Court, Gauteng Heritage Resources Appeal Tribunals, senior commissioners through the South African Local Government Bargaining Council, chaired the Gauteng Rental Housing Tribunal, CCMA Commissioner, a range of disciplinary committees, National Home Building Registration Council, Council for the Built Environment, the South African Council for Planners, and in the public and private sector. Why do I say these things? Simply because I've spent, as I say, a lifetime in the independent tribunals as provided for in the Constitution. All of those are adjudicative bodies. They apply the Constitution, they apply the Bill of Rights, they have a set of procedural rules which one must follow, and of course they apply the law in those areas. I've simply handed down thousands of rulings, whether they're rescissions, condemnations, awards, orders. I've had a range of senior counsel appear before me. As we currently speak, I'm chairing the Appeals Committee of the Council for Medical Schemes, which is a complicated area of the law. I've drafted legislation. I've trained members of the Gauteng Consumer Affairs Court and the Rental Housing Tribunals, amongst others. I've drawn manuals and trained people on how to present cases before adjudicative bodies, and that runs to all the usual rules of evidence. I teach from time to time at WITS. I've done impact assessments. I've made presentations to Parliament on aspects of the law. So what I'm saying to you today is that, yes, it hasn't had the high profile necessarily of courts. I've acted in the Labour Court. You would have picked that up. And really what I want to say today is that my experience generally is it's actually a lot tougher being down in those tribunals as opposed to being in the courts for a range of reasons. The first thing is that courts have, you have the protections of the office, the status, all of those things. You have appearing before you counsel and lawyers from almost all the time. The law is being presented to you in a sanitized fashion. There's respect and so forth. Down in the tribunals, and I really just want to say that if the Constitutional Court was the biggest judicial development in our transition and growth into democracy, the next biggest development has been the growth of independent tribunals. I've just listed out the ones that I've been involved. There's the Competition Tribunal and others. So what I'm saying to you is that what I've also done, and really my interest in the law has always been, and this goes back to the early 80s when I joined in the 80s when I joined the Legal Resources Centre as a human rights lawyer, is how does the law affect meaningfully the lives of people? And as a result of looking at that, what I've realized in time is that there's a complete imbalance of resources in our country. We know in our country that race still matters, that poverty and those things all still matters. It's not something that we can disregard. And so too it is that down at the level of the tribunals, is that there you've got the average man and woman. In other words, the little men and women coming before you. They come before you because they may not know what the law is, but they know that they seek redress. And simply what I've had to do over the last 20-odd years is essentially to some extent, sanitize what the real issues are. You don't need to do that generally as a judge because it's being presented for you. But what, down at the tribunal level, you have to interrogate and get to the issues. And this is why I believe that I introduced a unique and special form of procedure in the Rental Housing Tribunal. And it really came out of my observation that essentially the more resources that you had, the more likely you were likely to win. Because partly the average man and woman does not know how to put versions to the particular to the other witness. And so often what would happen, and we know as lawyers that if versions are not being put, then that can affect the outcome of a case. So what I essentially did is that I introduced what I would call a slightly inquisitorial procedure, but it was through a conversation with the parties. So what it would mean, if you got to the Rental Housing Tribunal, for example, there are others, all you needed to do was fill in a form. You may not be particularly literate and educated, but you know that you seek justice. And what I would do is through a facilitative conversation between the parties. What is your story? Just tell your story. Then say to the other side, well, what do you, for example, say to that? And I'll give you a fairly easy one in the context of evictions. Is that a tenant would come before the tribunal, and you'd say, well, why are you here? And they'd say, well, we've been evicted. And then we would say, well, then you would say, well, could I perhaps have the court order? I'd like to look at it. And he would say, no, I haven't got a court order. Then you'd look to the landlord and you could say, could you please provide me with a copy of the court order? Because we all know that under Section 26(3) of the Constitution, you cannot be evicted without an order of court. Well, what transpires then is you say, well, Mr. Landlord, we're bound by the Constitution. We live in a constitutional democracy. You haven't presented to us. That means that we need to put you back, need to put the tenant back in the in occupation of the lease. But as a matter, and that's what we have no choice, and we will do it. But as a matter of interest, please just tell us why you evicted the tenant in the first place. Well, he said, well, he didn't pay the rent. Did you send him a letter? No, he didn't. Those things. Then you'd say to the tenant, did you not pay the rent? He said, no, I didn't pay the rent. You said, well, why? And invariably, it's now January, February in the year, Christmas, and people who have had expenses and so forth. Sometimes they've been at funerals and those sorts of things. And you say to them, you're happy to pay the rent in due course, and the tenant would say yes. And what you then do is you'd end up putting together an order, which would be as follows. And you would say the tenant is reinstated in occupation.
Let me just help you, Mr. Bailey.
Yes.
It would help if you could tell us why you consider yourself to be the right person for a position in the Electoral Court. In other words, what is it that you know about the Electoral Court? How do you see yourself making a contribution in that court? Upon reading the Electoral Act, what are the issues that you think needs to be highlighted to demonstrate your suitability for the position, and so on and so very as briefly as you can. I think that really would help. Over and above what you have already said, it would help if you could tell us, even your observations about how the court operates or has been operating over the years, and what changes, if any, you think need to be brought about, the importance of the court from your viewpoint. If you could just briefly touch on those issues, yes. Then if there are questions will be put to you. If there are no questions, then we'll excuse you.
Thank you, Chief Justice. Well, first of all, I have a commitment to constitutional values, and I have a commitment to human dignity, freedom, equality, fairness. And you've got to apply them with empathy and compassion. And I believe that those two qualities I will bring to the court. There's no doubt that you've got to have due regard to the concepts of the separation of powers and the vision for social transformation in this country. You've got to act independently, impartially, and act ethically and honesty. I think in any court, you've got to have judicial temperament. Humility, open-mindedness, courtesy, patience, thoroughness, decisiveness, and you've got to be industrious, and you've got to be qualified in the relevant body of the law. So those are just the general judicial requirements that I think I would be able to bring to the courts. I think that the court's heard 35 cases since it came into operation in the late 90s. Last year, the court heard 5 cases. It was significant. And I think that obviously everyone knows about the high-profile case of the Clockware judgment, which simply certainly set some parameters. Obviously, that dealt with, and this is the significant point, is whatever this court does, it's got to ensure that there is respect for the election process, because we all know that elections run to the heart of our democracy. So clearly, in that sense, you've got to have a very clear commitment to understand what the separations of powers are. I also think, and all of us in this room, I sit before a mighty intellect, are aware of the issues that go on in our country and so forth. And so I'm going to suggest to you, and certainly say that, that the court needs to act without fear or favour. It's got to be particularly mindful of what the separation of powers is. It's not an absolute issue. Clearly, we live in a constitutional democracy and so forth. So I would bring with me an absolute commitment to understanding what that separation of powers is, how far the courts go. I don't believe the Electoral Court should get into opinions. I don't believe the Electoral Court should go wide. It needs to concentrate narrowly on the issues before it. What it also needs to do is, it doesn't matter what the noise is outside of the court. There's an absolute commitment from my part to take that noise and ignore it, to look narrowly at the issues, to properly read the papers and decide the case on the papers. And what I would particularly be able to bring to the court is my experiences doing investigations. One of the powers that the court has is the ability to investigate. So I would be able to bring with me a methodology around investigation, certainly be able to test how those investigations were carried out effectively. Are they reasonable? Are the conclusions justifiable? All of those sorts of things. Test the methodology that was used, so that the information that would perhaps be put before the court is reliable, and even to the extent that the court itself needs to go out and investigate violations of the Electoral Act and the Electoral Commission Act, then I would certainly be able to bring that to me. I see effectively one of the powers that the court has is that if you don't comply timeously, then effectively you're barred, but of course you still have the right to apply for condonation. I deal with those issues on a daily basis. I'd be able to apply all the law in terms of the requirements of reasons for lateness, prejudice to the parties, prospects of success, and all of those things. I'm comfortably very, very comfortable at a procedural level to make calls where it needs to, and I believe that what I would always do is that there's a discretion under the Electoral Act and in terms of the rules to ensure that that discretion is always used for the purposes of freedom and fairness before the parties. And I want to say this to you today. Any party that leaves the Electoral Court, if I have been sitting there, will have been treated with courtesy. They will know that I have read the papers. I might challenge them. I might ask questions. But they will know that I will do all of those things. And I will then be party to I'm happy to write the judgments of the court if needs be. I will then apply my mind, and they will see that there is, as is currently the case in any event, because the judgments are written by some very experienced people, and they are clearly and reasoned, but I would try and contribute to that. what is interesting for me, and this can simply only be an observation, is if you look at the rules, it talks about dealing with matters within 3 days, getting your papers in and so forth, then it seems to me that there does appear to be a period of time where essentially before the court starts to sit. Now, I'm not saying that as a matter of criticism, that's just an observation that I simply picked up. And that while the rules clearly are indicating that things need to be done quickly, and it's understandable because by and large the court will sit in and around elections. These violations are happening in and around election time. You've got to get it sorted out quite quickly. So I don't make that's certainly not a comment of criticism. It just appears to be an observation. And so what does that perhaps mean? Much in our country is made around ability. I want to suggest to you that we also need to talk about availability. And so I work for myself as a private adjudicator and a regulatory lawyer. Is that because I plan my diary, I will be able to make myself available when and as needs be. The way the court's likely to continue to work in terms of its jurisprudence, I think the Clockware judgment handed down by the Constitutional Court has laid down certain markers. I think there's still going to be quite a bit of debate around, balance of convenience, versus the requirements. I know that has been tested, but I think it's going to come back in different guises and different forms before that court. And so clearly what we're going to need to be there simply be alive to what's been said. Start also just simply to look at what has been said at the obiter level of the court, and continue, I think, simply continuing to build and enhance the jurisprudence of the court in and around the parameters that have certainly that the Constitutional Court has laid down in terms of its markers.
Thank you very much. Judge President Shongwe.
Thank you, Chief Justice. Mr. Bailey, are you a member of a political party?
No.
You're not? Never been?
Correct.
I take it you are familiar with the legislation, that is the electoral legislation, the Electoral Act, the Municipal Electoral Act, the Electoral Commission Act.
Yeah. I can't stand here before you today and say that I have a deep knowledge of it, but certainly I have some knowledge of it. It would be wrong for me to say that I have a deep knowledge of it.
Yeah, I use the word familiar.
Yeah. Yeah.
Yeah. Well, in your practice, as an attorney, as a person who dealt with tribunals, dealing with rental issues, leasing issues, have you had experience in high court practice?
I have. So when I was practicing law at the Legal Resources Centre, there effectively I joined them, and I think this is important. In 1987, height of the state of emergency. At that point, I was acting for detainees. We were trying to get them released. I was acting for members of the public who were detained, who'd been beaten up. So there was a range of damages claims at that level.
Yeah, what I mean is, in your practice, how would you say the percentage of your high court practice? Well, how would you put it?
Certainly the last time I in fact had a matter in the High Court, simply it was when I was acting for the National Consumer Tribunal in a matter, and that would have been certainly about 6-7 years ago. I haven't, and I in fact had made a specific decision in and around my practices that I simply wouldn't necessarily be in the High Court, because I've spent, as I've indicated to you, all this time simply in the tribunals. But I want to simply say to you, sir, is that I don't believe that that's an impediment at all. I will come with a complete range of other skills. The other thing is that if you're going to practice in the High Court, as an attorney, it's all about the rules. It's about knowing what those rules are. In every single tribunal which I've worked at, I've been party to writing up rules. Rules set out how you litigate. So the short answer is very little in the recent past.
Very well. Now, in your work as a person who deals with tribunals, you sit as a single person, or you sit in a panel?
Yeah. Generally, the tribunals are as a panel. And often depending between 3 and 5 in almost all of the bodies that I've referred you to, and even the disciplinary panels in which I've sat in with the professional bodies and so forth. I sit with a panel, and one of the most fulfilling experiences, sir, that I've had on these panels is simply working with a range of experts in these myriad number of industries in which I've had the privilege of operating and across, whether they be race, gender, those sorts of lines. It's been a meaningful story of the new South Africa.
Sitting as an acting judge in the Labour Court, I saw that you have said as an acting judge in the Labour Court. Now, how long have you sat as a judge, acting judge in the Labour Court?
I sat essentially there for about 6 or 7 days. I was part of the profession's contribution through the South African Society of Labour Lawyers that assists with the backlog. Certainly all I want to say to you for what that meant is that the papers that arrived, essentially if we loaded them up, they would have, for those 7 days, would have been higher than this desk. Also, what I want to say around this is I found acting in the Labour Court easier than effectively in the tribunals for the range of reasons that I've already given, because for the reasons that I've given already. I really want to say that to the extent that that is clearly going to be part of your applying of your minds around this Labour Court, around the lack of High Court experience. I want to say to you today, I don't believe it's going to be any impediment whatsoever. Let's think about the Electoral Court if I can. The Electoral Court rules essentially run to about 5 or 6 pages. It's a very simple procedure. Effectively, as I looked at them, I thought this is what I've been dealing with for many years. I've taught how to present cases. The law of evidence, whether it's on application or whether it's by way of action, is applied throughout the tribunals, and everything is essentially the same in that regard. So I'm saying to you that I think that I would bring a range of other skills that simply, even if I had been practicing in the High Court, that I would simply not have acquired in terms of the work that I've done at the lower level.
Now, in that period, when you said as an acting judge, did you have an opportunity to write a judgment or judgments?
I think I ended up writing about 9.
9 judgments.
I'm subject to correction, but essentially I was there there was 5 days, and there were sometimes 3 a day. One occasion might have been 4, others 1. It depends.
So, in the period of 6 to 7 days, you wrote about 9 judgments.
Well, those are the ones that I've given, yes, subject to correction. I haven't done the count, but within that arena.
I see. Now, the Electoral Court, as you know, is a specialized court. You talked about the question of availability. And it is basically, essentially, an urgent court. I'm sure you've heard of the urgent court.
No, indeed I do. Rule 6, High Court rules.
Now the sittings may be such that you get papers today. You have mentioned about 3 days that the other party has in order to respond, and the court may sit a day or 2 thereafter. And you say you will be available as and when you are called to.
Yes. By and large, I think the answer to that would be generally yes, I can control my diary. The other thing I do want to say to you is that, I sit also as a commissioner, part-time commissioner down at the CCMA, And I, in fact, have a very comfortable arrangement with the case managers there. So, yes, I've spoken about availability, and I believe that I would be able to do that, yes.
Amongst other things that you mentioned in your CV is that at some stage you were involved with the Independent Electoral Tribunal. Can you just tell us a little bit what that tribunal is and what your position was in that tribunal?
Yes, and that was the tribunal was set up to oversee the 1994 elections. And obviously I was appointed to that as a commissioner. I sat out it was in fact a very interesting experience for me for a number of reasons. One, because I'd spent all my time at the Legal Resources Centre, in a sense, fighting the system. So we were always on the other side of the bench, so to speak. And so here I found myself essentially heading off to the Germiston and the Springs Magistrates Court, where these cases were being held. And it was an interesting experience for me. Here I was sitting with people who I would have perceived perhaps as being apartheid magistrates and so forth. And they were very, very gracious. I effectively was given the best the courts. I effectively heard two matters, to the best of my recollection. A lot of that information is now sitting with the Legal Resources Centre. But I have to say to you, sir, that they were rather minor skirmishes. One related to, and between minor parties at the time, and as you know, there were lots of the parties. One related to statements that had been made were perceived to be defamatory between parties. The other one essentially related to some leaflets that parties felt were not true.
So basically, you said as a commissioner.
Yes, indeed. I heard the cases ran effectively. Yes, that's what I did.
Thank you, Chief Justice. No more questions.
Thank you very much, Judge President Shongwe. Commissioners, any question?
No,
Thank you very much. You're excused, Mr. Bailey.
Thank you very much for listening.
Thank you.
Thank you.